During a pretrial settlement conference in front of the judge turns around and tells me that you should accept this settlement offer. I tell the judge, I'm sorry, Your Honor, my client refuses to accept this offer. It is insufficient. What happens in that case? Want to know what happens? Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. All right, you believe your case is worth 5 times what the defense has offered, and you reject and refuse to accept their settlement offer. Now we go in front of the judge, and the judge is putting pressure on me to get you to accept this offer, telling me that the defense doesn't have another dime, and this is all they have and all that they are going to offer. I explained to the judge why your injuries are worth so much more than what the defense has offered in this case. Does this mean that now you are going to go to trial? Does this mean that the defense will not offer any more additional money? Does this mean that a jury, if your case goes to trial, that a jury will come back and give you substantially more money? I'll tell you what this means. It means that the judge, during a brief pretrial settlement conference, believes that the defense has no more money to offer, and based upon the comments made by the defense attorney and myself, he believes that not only will the defense not offer any additional money in terms of settlement, but that a jury will likely not give you half as much or nearly as much as what is currently being offered. The judge is trying to pressure us, and likewise the judge will have pressured the defense to come up with a substantial offer. So does this mean that your case is going to win a trial? The answer is no, that's not what it means. Does it mean you're going to lose a trial? No, that's not what it means either. It means that during this brief conference, the judge has determined that he will try and pressure us to accept the settlement offer. And if the defense is unwilling to offer more money, the judge is now going to set your case down for trial. Now, as your case goes to trial, you will be relying on 6 members of the community to evaluate whether you are slightly more likely right than wrong than what you are claiming is true. That number 1, that the doctor was careless. And number 2, that his carelessness was a cause of your injury. And number 3, that your injuries are significant and or permanent. If the jury finds in your favor in each one of those things, now the jury will have to decide how much money you are to receive for all of the harms and losses and damages you incurred as a result of this carelessness. Don't think for a second that just because the jury has reached an answer in your favor for each of those things, that they are going to give you substantially more than what the defense has offered during pretrial settlement negotiations. Because sometimes what can happen is the jury may find that your injuries are not worth what you claim them to be. On the other hand, there are instances where a jury will come back and give you substantially more than what you believed your injuries are worth. There could be many different outcomes and many variations of the outcome, and that's the issue with going to trial. You never know exactly what a jury is going to do. And many times the defense will turn around in an effort to try and minimize their risk, will make a settlement offer in the hopes and expectations that by settling this case for a definitive amount before your case goes to trial, they manage and minimize the risk of exposure by having a definite settlement. And in that instance, now, if you are willing to accept that, your case is done and finished. If not, you go to trial and then rely on a jury, 6 members of the community, to decide your fate. Want more information about how these cases work in New York? Follow me. Have questions about your matter? Well, if your matter happened in New York and you have not yet started a lawsuit but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.